Welcome to Washington Legal Foundation's media briefing on the U.S. Supreme Court term. My name is Glenn Lammi. I am the Executive Director and Vice President for Legal Studies here at the Foundation. For those of you not familiar with the Foundation, this is our 47th year of free enterprise advocacy, education, and litigation. We are very active at the Supreme Court and do a lot of writing and speaking on it as well. If you have any time after the briefing, check out our website at wlf.org. And you can see what we're up to in this area. Even though the justices have only released 3 written opinions at Midpoint here, October term 2023 is already one of the most compelling terms in recent memory. And it's really only going to get more interesting over the next 5 months. So far, the court has heard arguments in 5 cases in which WLF filed amicus briefs, and we've either already filed or will file in 5 more cases scheduled for argument in the next 3 months. Our 4 appellate experts today will focus on some of those cases, as well as others of interest to our mission, a bit of discussion on at least one of the decided cases, and finally, pending cert petitions as well. We have a lot of ground to cover, so let me briefly introduce our panelists. Michael Kenneally is a partner with Morgan, Lewis & Bockius, practicing in the firm's Washington, D.C. office. Before joining the firm, Michael clerked for Justices Antonin Scalia and Samuel Alito and Judge Neil Gorsuch when he sat on the 10th Circuit. And Voights is a partner with King & Spalding in the firm's appellate, constitutional, and administrative law group, practices in the firm's Silicon Valley and San Francisco, California offices. Prior to joining the firm, she served as a law clerk to Justice John Paul Stevens and as a law clerk to Judge Stephen Reinhart of the Ninth Circuit. Erik Jaffe is a partner in the Washington, D.C. office of Schaerr Jaffe. He spent 2 decades as a sole practitioner, focusing on appellate litigation before joining the firm in 2018. Prior to that, Erik practiced law at Williams & Connolly and served as a law clerk to Justice Thomas and to D.C. Circuit Judge Douglas Ginsburg. Finally, Jonathan Ellis is a partner in the Raleigh, North Carolina office of McGuireWoods, for which he is co-chair of the Appeals and Issues team. Before joining the firm, Jonathan served as an assistant to the Solicitor General in the Office of the Solicitor General of the United States. He formerly clerked for Chief Justice John Roberts and D.C. Circuit Judge A. Raymond Randolph. Our panelists ask that I say that the views they provide today are their own and don't necessarily reflect the views of their firm's clients or their employees. I also note that this program is being recorded. Please consider asking questions if you have any during the program using the Q&A function in the bottom of the Zoom webinar toolbar. I will check the questions as they come in, and if there are ones that flow in well with our discussion, I'll ask them at the time. If not, I'll hold them till the end of the discussion. So let's start our discussion on one of the 3 decisions the justices have released, Murray versus UBS, one of the cases that WLF filed in. Michael, some of your colleagues at Morgan Lewis authored an amicus brief in that case. What was the court's reasoning and what will be the decision's implications?
So Murray was a unanimous decision, and like a lot of unanimous Supreme Court decisions, a lot came down to the framing of the question before the court. The question in general was whether an employee whistleblower statute, in this case under Sarbanes-Oxley, was confined to adverse employment action that was taken with quote-unquote retaliatory intent. And here's where the framing of the question becomes really important. The court defined retaliatory intent as essentially animus or hostility to the protected whistleblowing activity. So the issue, in other words, was whether the statute required proof of hostility toward the whistleblowing activity itself. Once the court framed the question that way, I don't think anyone was terribly surprised with the decision it reached, because the court made a pretty basic point. There is no hostility requirement in the text of the statute, and therefore the court has no authority to graft such a requirement onto the statutory language. And I think the employer in the case seemed to anticipate that rationale, because they argued that the Court of Appeals hadn't really adopted a hostility requirement when it ruled in favor of the employer. The Supreme Court disagreed with that reading of the Court of Appeals decision, but even it agreed that the statute does require proof that the employer intentionally treated the employee worse because of the protected whistleblowing activity. And so that kind of raises the question what the fight here was really about. And I think at the end of the day, it may have, the fight may boil down to concern about one of the jury instructions that the trial court in that case gave. which allowed the jury to find liability if the whistleblowing activity tended to affect in any way the employer's decision to terminate the employee. And both the employer and the appellate court expressed concern that that broad instruction went too far in allowing the jury to find liability. And the Supreme Court didn't really disagree with that, didn't endorse that instruction, and in fact said that the Court of Appeals could consider that issue on remand. I would argue that the Supreme Court's reasoning isn't really compatible with that jury instruction. But at the end, in the end, I think that this case on the surface looks like a loss for the employer and for employers more generally as they face whistleblowing claims. But I'm not convinced in the long run it's going to end up being that useful to the plaintiff's bar. I see it more as a narrow decision that really addressed this very particular animus requirement.
Thank you, Michael. Jonathan, the court's opinion in Murray really kind of closely tracked arguments, the brief that the Solicitor General filed in support of petitioner put forward. The U.S. also strongly urged the court to find the claim in Atchison Hotels, the ADA tester case, moot, which it did in one of the other two published opinions. Are there any cases that you've seen that are coming up in the second half of the term where the U.S. has filed a non-party brief where you think the SG will have a similar influence?
Yeah, so look, I'm not one to downplay the SG's influence before the court, but to be fair, I'm not sure the result in Atchison really was a great example. I think Justice Kagan put it in argument there. That case was dead before it got to argument. But I think the sentiment of your question is correct. OSG has historically held a great deal of sway with the court. And its briefs frequently carry a good deal of weight in the resolution. I think the reason for that, before I give you my cases here, I think is that the office has emphasized its credibility before the court. It's the sort of the ultimate repeat player, and it prides itself on sort of playing it straight and in its role as expressing the views of the executive branch and defending the actions of the court's coordinate branches. That doesn't always mean victory, of course, particularly where the president comes from a different party than a majority of the justices, the president who appointed the majority of the justices, and therefore might approach the court's interpretive questions based on different perspectives and different first principles. But there are a good number of cases each year where the cases are decided based on sort of common tools of legal interpretation and their view of precedent instead of sort of highly contestable first principles. And I think that's especially likely to be true in cases, as you suggest, where the SG is participating as a non-party. On those questions, I think that their views will always warrant consideration. So where do we think that it's going to happen again this year? Predictions are fraught, but I'll venture 3 cases I think that are going to either have not been decided or had not been argued, where I think the SG's views are likely to carry some weight. The first is maybe a bit of a cheat. It's Smith v. Arizona that was already argued, but hasn't been decided. This is a confrontation clause case that was argued in January. It's a case between a criminal defendant and the state that concerns the practice of so-called substitute experts to testify about the results of a drug test or other forensic analysis. So ordinarily, this is a case where you expect the federal government to come in on the side of the state. After all, the confrontation clause binds the federal government just like it does the states. But here, the SG filed a brief in support of neither party, disagreeing with the state court's reasoning in affirming a criminal conviction and urging the Supreme Court to vacate that decision and remand for reconsideration as to whether the confrontation clause actually had been violated and the criminal conviction should be vacated as well. That's a sort of against interest argument and brief that I think is likely to carry some weight with the court, and I think you saw that at argument. The second case is the one that I think we might discuss a bit more in a bit, but that's Warner Chappell Music v. Neely. That's a case about damages, the damages that are available in a copyright action and accrual rules. Not exactly front page news most days, but it's the type of case where I think the court's likely to look to the government as sort of a neutral arbiter of those sort of neutral principles. And to the extent the court wants to consider the underlying statutory structure of the Copyright Act, certainly the government can bring to bear its expertise from the Copyright Office in a way that carries some weight with the court. And the last, I think, is a case called Gonzalez v. Trevino. This is yet another case. There's been many in recent years where the court will consider the contours of a constitutional tort under Section 1983. this is here the case is about the elements of a First Amendment retaliatory arrest. Somewhat like Smith, this is a case where the federal government at least is somewhat similarly situated to the state. The court has held that the contours of a Section 1983 tort and a Bivens tort are largely coextensive, at least where Bivens torts continue to exist. But there's an interesting wrinkle in all these Section 1983 cases that I saw when I was in the government. These are the types of claims where there's a particular interest at DOJ, tends to be a particular interest at DOJ by both the criminal division and the civil rights division, but they're often coming at it from different perspectives, opposite perspectives. OSG's brief in Gonzalez is another neither party brief that tries to thread the needle between the two parties in a way that will vindicate constitutional rights and claims in some circumstances, but without opening the floodgates. And I think that kind of approach is going to carry some weight with the court as well.
Thank you, Jonathan. One of the other cases that the Solicitor General filed a non-party brief is Net Choice versus Moody and its companion case. Erik, you represent 4 free market nonprofits on one of those many amicus briefs that were filed in those 2 cases. Can you take a few minutes to give us the sense of what the issues are in that case?
Yes, of course. So yeah, we represented Reason and Committee for Justice and CEI and Taxpayers Group. And, you know, this is sort of one of those interesting cases where it sort of splits the political parties down the middle. The libertarian leaning parts of either party go one way and the government authority parts go the other way. And you can't really predict it based on, you know, what you think those first principles are. The government's brief, I thought, played it pretty straight. It was what I would consider sort of straight up traditional First Amendment doctrinal works. Obviously, the 2 states, Florida and Texas, you know, are looking to precedents and to reasoning that once upon a time was saved only for folks on the other side. So it's really quite interesting. The issues there are several fold. There's a lot of moving parts. The first big one is, are these platforms, you know, X, Meta, you know, Facebook, YouTube, those kind of platforms, are they speaking themselves or engaging in speech activities, or are they merely transmitting the speech of others? And of course, the whole fight comes down to, what do you think the role of editorial decision-making is? Do you think they're engaged in it? Have they presented themselves as a conduit as opposed to a magazine or a letters to the editor style conduit, where it's really a curated conduit? And that's much of the fight that I think the 2 sides are having. One side views them as the telephone company, where they just pass it along. The other side views them as a magazine or as letters to the editor from a newspaper, and they're seriously curating what they present. I think it's not even close, in my opinion, that they're obviously curating it. This strikes me as embarrassing and laughable, but lots of judges that don't agree with me, so I guess the joke may be on me. But we'll see. What I can say is that we've had lots of cases like this, dealing with newspapers, dealing with the Boy Scouts, for that matter, once upon a time, where we have big popular activities that have an expressive component to them and some other components to them, and we've routinely treated them as expressive. Our brief took the position this is actually freedom of association. So stop thinking about who's talking and think about who's associating with the people talking, and maybe it will be easier to get your head around it. Other issues that crop up are, is this a common carrier? Is it like the telephone company or the railways? I think that's the same question as, is it a public accommodation? We've seen that kind of argument crop up a lot. Like I mentioned in Boy Scouts, we see it crop up a bit in the cake baker cases and the 303 Creative website cases. Are you a public accommodation because you offered a service to the public? And so far, the court has generally said no. We'll see where they go, because obviously members of this court have expressed a lot of hostility to the big tech companies. Another issue that crops up is this modern public square phrase that you keep hearing people say a lot. And the great irony is watching them cite the Pruneyard, a decision that was reviled by conservatives for years and is now flown like the flag of freedom or something. That's a great pleasure to watch that inversion, not to mention the implicit call-outs to Red Lion, another decision that was reviled by conservatives and by me personally. So we talked about that in our brief a little bit. The last issue, or last 2 issues of interest to your audience perhaps, is one is the so-called Zauderer issue of, can you force companies to disclose certain information in the context of commercial speech? Here, the question of disclosure boils down to, can I make you explain to me in detail why you kicked me or my post off of your platform? And it takes about 20 seconds to sort of ask, do we really think you can make the New York Times or the Wall Street Journal explain each of their editorial decisions and why they rejected your letter to the editor? And when we all conclude no, hopefully that takes care of the Zauderer issue, but somehow I don't think it will. It certainly hasn't persuaded several judges. But again, you know, the key is it's a communicative exercise. It's not a product exercise. It's not a transactional solicitation. It's not really commercial speech, though I think your audience, you will debate about, is it or is it not commercial speech when I retransmit you and make profit on it. Lastly is the 230 issue, section 230, which insulate these platforms. A lot of people use this as an excuse to say that therefore they have to be neutral conduits. All I would say to anyone who thinks that is try reading 230, where it does not assume neutrality, not even close. And even if it did, to make it a condition of exercising your First Amendment rights strikes me as an unconstitutional condition. So you can repeal 230 if you don't like the way it's working, but I don't see how you can condition its immunity on waiving your First Amendment rights. That's the quick summary. As you could probably tell by my attitude and sarcasm, I think the answer to this case ought to be obvious, and I fear desperately that it will not be unanimous and it will not be easy.
And WLF's amicus brief urged the court to use net choice cases as a vehicle to clarify the proper First Amendment test for compelled commercial speech, which has been quite confused over across a lot of the appellate courts in our perspective. You think there's a chance the court will do that?
I
think they sort of have to reach some version of Zauderer, yeah.
Yeah, and I think it's certainly possible, and we hope that they do, right? I mean, so to Erik's point, one of the things that the two issues that are before the court, one is the content moderation, the second are the individualized explanations. And if you can imagine for some of these platforms, an extraordinary number of posts, the idea that you would have to explain every time in detail why you rejected a particular post, why you took it down, you know, is a pretty extraordinary burden. But nonetheless, you know, at least, you know, one appellate court thought that this was enough under Zauderer, that there was a real justification for it. And Zauderer has typically been viewed, at least when the Supreme Court wrote in Zauderer, they're talking about commercial advertising, right? And so the idea was that you could compel disclosure, you could compel speech by a company or by someone if it was factual and well established and not controversial, and if it was reasonably related to the state's interest in preventing the deception of consumers. And that's a little hard to square with the type of speech that we're talking about here, right? Where you're explaining why you take something down because it is hate speech, because it is, you know, falls into any of a range of categories that we normally think of as falling within editorial discretion. So there's an opportunity, because the courts have been really split over what Zauderer applies to, how to apply it. There is an opportunity for the Supreme Court to clarify that. And, you know, if you are looking for a good piece of bedside reading, I highly recommend WLF's amicus brief. It is a banger, as my kids would say. But it is, you know, the question is, will they decide to do that? You know, the court itself has introduced some ambiguity into the issue when it restated the test recently without saying that disclosure has to be necessary to correct deception. So we'll see if they do some cleanup in this process, or if they just say, you know, Zauderer doesn't apply, so we don't need to resolve all of these issues that are out there.
Michael, Jonathan, any thoughts on net choice cases before we move along? Okay.
No, and I might, Glenn, I was just going to add to Jonathan's point earlier about the influence of the SG's briefs. So at the amicus stage, they called for the views of the Solicitor General in both cases, and the Solicitor General sort of restated the questions and said you should grant cert on two, the content moderation and the individualized explanation, and you should reject cert, deny cert on the other two questions. And that's in fact exactly what the court did. And I think, you know, that has played a really important role in shaping the issues that are actually in front of the court now.
So the court's going to hear another case in the First Amendment realm in March, NRA versus Vullo, where speech rights come up in a pretty unusual context. And what principles will the court contemplate when deciding that case?
Sure. So this is an interesting case. First off, you have the NRA being represented by the ACLU and Eugene Pollock, which is sort of an interesting combination to have together. And the issue comes out of a suit that was brought by the NRA, challenging the exercises of the superintendent of New York's Department of Financial Services Authority. The superintendent oversees thousands of banks and insurance companies and can grant or deny licenses, can launch investigations, and basically has sort of, extraordinary power, and normally exercises it to ensure compliance with banking and insurance laws. In this case, NRA alleges that the superintendent targeted the NRA for its gun promotion advocacy and issued formal guidance letters and press releases telling banks and insurance companies not to do business with the NRA, and said she would offer enforcement leniency to insurers if they stopped working with the NRA, and announced consent orders with 3 longtime insurance partners that involved fines, and barred them from entering into commercial partnerships with the NRA ever again. And those companies, in fact, did. And so the district court said, look, on a motion to dismiss stage, we have to take these allegations as true, and this is sufficient to state a claim, and a claim under the First Amendment. But the Court of Appeals actually reversed, dismissing this as government speech. So the question in front of the court is, does the First Amendment allow a government official to threaten regulated entities with adverse regulatory action if they do business with an advocacy organization that holds views that the government official disagrees with? And so the question for the court is going to be, where do you draw the line between the government's ability to sort of try and exhort and persuade, as the SG puts it, as opposed to the attempt to suppress protected speech? I think there's the general expectation is that they'll probably reverse the Court of Appeals on this, but it'll be interesting to see how they do it and where they draw those lines.
Jonathan, any thoughts you'd like to add to that?
Yeah, I agree. It's a fascinating case. I think that it involves several different areas of law that are pretty murky. Principally, the difference between coercion and persuasion. That's an area, sort of a principle that cuts across the state action doctrine, which is also open before the court this year. It comes into play for the unconstitutional conditions doctrine. And I think what you if you take a zoom out and look at those cases, what you find is that the court has a real hard time articulating clean lines there. And sort of takes these cases on a common law basis, case by case, and I expect they'll do the same thing here. The other point I'll note on the Vullo case, it reminds me a little bit of the pork producers case from last year, where there's the doctrine that you're fighting about, and that was a dormant commerce clause case, so it was a different doctrine. But then there's the concern, the sort of policy concern. In pork producers, it was that California has this massive market that they could then use to wield to sort of project their morals onto the rest of the country. And I think the NRA and Union Bollock and ACLU's brief tries to tap into that same concern, saying that New York is the center of the financial world, and it has that same sort of ability to project. That didn't work. That got a lot of play and argument at pork producers, but ultimately was it enough to get the court to rally around a dormant commerce clause claim? I'll be curious to see how that plays here and if it affects the result.
Erik, any thoughts?
Yeah, we have a brief in that for a privacy group, just sort of noting that at the point that you allow this sort of behind the scenes strong arming, it's not just First Amendment stuff that matters. They could coerce banks to release data on particular clients. They could get around the Fourth Amendment. They could do lots of things. I absolutely agree that the court's cases in the unconstitutional conditions situation, in coercion and state action, are not as clean as I would like them to be. And you get seemingly inconsistent outcomes depending on the case. I hope they give us a little bit cleaner standard, even if it's not an absolute bright line, something to measure that sort of says, stay away from deciding that their speech is the reason you have to dump them. I understand if you can't have a bank that's about to collapse as your clients, it might make you collapse. But this is pretty disturbing. I think the result will be right. I hope for a decent opinion.
Thanks, Erik. So let's turn to an area where the Roberts Court has focused a surprising percentage of its somewhat meager merits docket over the past 10 years, which is arbitration. The second time in 3 terms, the court will consider the so-called transportation exception to the Federal Arbitration Act. Michael, you authored an amicus brief for Amazon in Bissonnet versus LePage Bakeries. Why did the court grant this case, and what's sort of at stake here?
This case is centered on a threshold issue that arises for certain kinds of arbitration agreements. As a general rule, the Federal Arbitration Act applies to all sorts of arbitration agreements as long as they have some nexus to interstate commerce. But there's an exception for contracts of employment of seamen, railroad employees or any other class of workers engaged in foreign or interstate commerce. And 2 decades ago, the court ruled that this language, which has been in the FAA since 1925 when the statute was created, doesn't extend to all employee arbitration agreements that are connected in any way with interstate commerce. Instead, the workers at issue have to be transportation workers. And I would say over the past 5 or so years, there's been a real surge in litigation over this exemption's applicability, in part because the Supreme Court's ruled in a case called New Prime that the exemption is not limited to traditional employer-employee relationships, but also applies to independent contractors. Several courts of appeals in the past few years split on the question that's teed up in Bissonnette, which is whether the workers, in order to be exempt from the FAA, need to work for a company that's in the transportation industry. Now, you might think that being a transportation worker kind of comes by definition with working for a company in the transportation industry, but that's not really true. I mean, especially in today's economy, think of a pizza delivery driver who works for a local pizza chain. They're not really working for a company that's a transportation company or within the transportation industry, but the individual driver is performing transportation services. And so the question in this case, again, is going to be, does the Arbitration Act's exemption confine itself to workers who are working for a transportation company? And I think what the big picture, what's at stake, is whether the Supreme Court is going to narrowly focus on that question about working for a transportation company, or is instead going to provide broader guidance to lower courts. Because Glenn, as you said, this is the second time in just 3 terms where the court has taken up this statutory provision, and the split that's in front of it in Bissonnette isn't the only issue on which lower courts are quite sharply divided over the point of its exemption. But the Supreme Court has been taking a very incremental approach, I would say, to this provision, even though it's generated a lot of litigation that I think everyone agrees is kind of a waste of resources, because the whole point of the Arbitration Act is to get disputes that are supposed to be in arbitration there as quickly as possible. But under the current uncertainty over this statute, you get appeals that drag out just that threshold question: where does this dispute belong, in arbitration or court? They drag out for years and sometimes result in remands that generate another round of appeals. And it's not good from anybody's perspective, but the Supreme Court has been very reluctant to give sweeping guidance on how to interpret this provision. So that's what I'll be watching in Bissonnette, is how much they stick to that approach, or they go more broad and try to clarify some of the other issues that are circulating around this provision.
The court's going to hear 2 more arguments in the second half on arbitration-related cases. Can you tell us briefly about those 2 cases?
Sure. So these are quite unrelated to the one we were just talking about. In the first, Coinbase versus Susky, the issue revolves around the use of a delegation provision, what's known as a delegation provision, and that is a part of an arbitration agreement that assigns disputes to an arbitrator, not just the underlying dispute, the parties' ultimate disagreement, but also the question of whether those issues are supposed to be in arbitration in the first place or should be in court. Now, the Supreme Court, in a series of cases in recent years, has been pretty, I would say, adamant about enforcing those delegation provisions. But in the Coinbase case, the Ninth Circuit said that it wasn't going to enforce a delegation provision where the arbitrability dispute to be decided is actually whether the first agreement between the parties controls, which is an arbitration agreement, or a second later agreement controls, which purportedly doesn't have an arbitration agreement. And on that issue, the Ninth Circuit said, we're not going to say that the arbitration agreement and the delegation provision in the first agreement require the arbitrator to resolve this, which agreement applies issue, but that was instead a question for the court to decide. And so then secondly, the next case is Smith versus Spitzeri. And the issue there, if you can believe it, might even be more technical than the delegation provision dispute in Coinbase. The issue in Smith is whether a court that is confronted with a request to compel arbitration and stay the litigation has to actually, if it thinks the dispute belongs in arbitration, stay the litigation, or can instead dismiss the litigation That's a technical question, but it's actually much more practically significant than you might think, because if the court dismisses the case as opposed to stays the case, the party that's dissatisfied with the arbitration ruling can take an immediate appeal, and the difference between staying and dismissing can also affect which court the parties have to return to after the arbitration, either to confirm the arbitral award or vacate it. So it's actually a very important issue on which the circuit courts have been split for a very long time. And so I think most people will be happy that the Supreme Court's decided to finally bring some clarity to that question.
Thank you, Michael. So the biggest argument in the first half of the term, at least in our world, involved the fate of the Chevron doctrine. The term's second half involves several more cases involving judicial review of agency action. Let's start with the Garland versus Cargill case, the so-called bump stock case. Erik, that's another case where you authored an amicus brief. Can you tell us a bit about the case and why the unappreciated rule of lenity may come into play?
Sure, of course. I did an amicus brief for FPC Action Foundation, which is a gun rights group. The issues in the case sort of break down in two ways. One, highly technical and sort of gun nerdish, and the other more important to the law in general. The gun nerdish part is the definition of a machine gun in the federal statute is quite technical, about a gun that fires automatically more than one shot by a single function of the trigger. And those words are complicated in how they interact, but if you are attentive and parse the details, you can sort of follow them through. My view, and I've litigated this issue several times, is that it's not, again, very difficult. Bump stocks, unsprung, non-spring-loaded bump stocks, don't do that. They require you to shove the trigger into your finger over and over again. Each time you want to fire a shot, you've got to shove your finger, the trigger into your finger. It just sort of helps you do that. Much like a stock helps you do that, much like a padded jacket helps you do that, or pretty much anything else on the planet, like a rubber band. The government, for a long time, agreed with this view of it until Las Vegas, and then the Trump administration ordered ATF to come to a different answer, mostly because he wanted to take the glory away from Congress, which was about to ban bump stocks. But ATF got there first, banned bump stocks without statutory authority, in my opinion, and Congress sort of slunk away. So that's the bigger question. It's less about the language of what did the statute mean. And there's lots we can talk about in the language, and lots that'll be interesting to see how attentive to detail the court is about the language. But it's these bigger structural issues of how much leeway do you give the executive branch to legislate when the legislative branch is sitting on its hands or dithering or taking too long or whatever you think they're doing. And those issues are important from separation of powers perspective, from a due process perspective. And here, as the case was litigated earlier and in other courts, there was a Chevron question. People kept saying, well, there's Chevron deference to an agency's regulation. That argument was based on a footnote in an old case called Babbitt. I think most people have largely abandoned that now. The government does not claim that. The government did not claim that before. Some courts adopted it on their own and gave deference even when the government tried to waive it. I don't see that being a big issue here because I think that will be laughed out of court or yelled out of court. The bigger question is lenity. If the statute, by some miracle, is held to be ambiguous, I don't actually think it is ambiguous, but I think to the extent that you give any credence to the government's interpretation, the best that gets them is an ambiguity rather than a clarity of their decision. The question is, how much uncertainty in a criminal statute needs to exist before the rule of lenity kicks in and you interpret that statute in favor of the defendant? It's almost like the inverse of Chevron. If there's uncertainty, what's the thumb on the scale? And in this instance, it would be for the defendant. The fight ultimately boils down to, do you need like gross uncertainty, serious uncertainty, or do you need any level of ambiguity such that you might otherwise create a difference in a non-criminal statute? I think the answer is ordinary ambiguity should be enough. I think that's supported by the notions of proof beyond a reasonable doubt and the criminal context, but the government disagrees. And that could be a big issue because I think the court will have a hard time just saying, too bad, so sad, we think this is what the statute clearly means. I don't think they'll say that in the government's favor. And I think they may be reluctant to say that in the defendant's favor. Therefore, it could come down to lenity.
There's a second case in sort of this general area, one where the business community is urging against judicial intervention into agency decision-making, FDA versus Alliance for Hippocratic Medicine. And you and your firm did a amicus brief supporting FDA's position in this case. Can you explain the issues in the case and sort of share your thoughts on whether the court will focus more on the standing question than on the Administrative Procedure Act claims?
Oh, yeah,
And
sorry,
actually,
Ann,
sorry.
please, sorry.
Sure. So this is a case about the use of mifepristone. But in 2000, the FDA approved the use of mifepristone for terminating early pregnancies. Over time, they modified the conditions of use using an alternative strategy that Congress allows FDA to use called risk evaluation and mitigation strategy. It's an alternative route for drug approval, but it requires FDA to determine that the strategy is necessary to show that the benefits of a drug outweigh the risks. And over time, as a body of data built up over how the drug could be safely used, FDA relaxed certain conditions about how the drug could be used, how it could be prescribed, and the requirements. And under the REMS framework, the approval can include elements to assure safe use. And so following that framework, the drug sponsor or the FDA can modify the existing REMS as they did here. In this case, the Fifth Circuit held that the respondents, who are doctors and associations of doctors who oppose abortion on religious and moral grounds and who don't prescribe mifepristone, nonetheless had Article 3 standing to challenge the 2016 and 2021 actions with respect to mifepristone's approved conditions of use. In that respect, it was a narrower decision than the district court decision, which had also encompassed that first 2000 approval. And they said that those actions were likely arbitrary and capricious. As the SG pointed out in their brief, this is, as best people can tell, the first time that an FDA approval of drug has been invalidated, or at least unlikely to be invalidated, when the court affirmed the district court's stay of the relevant agency actions. So the court has two questions in front of it. First, whether the respondents actually do have Article 3 standing with respect to how you can use mifepristone. And second, whether those actions in 2016 and 2021, relaxing the conditions of use, although still imposing heightened conditions of use compared to many drugs, were arbitrary and capricious. And then whether the district court properly granted preliminary relief based on that. And I think the standing question is an interesting one. The FDA's approval of the drug doesn't require a doctor who doesn't prescribe it to do or to refrain from doing anything. But the Fifth Circuit said they've still got standing because there's some statistical probability that some of their members might have to treat women who have had mifepristone and then have a serious adverse effect, which everyone agrees is relatively rare. That seems to have changed slightly before the court. You're acknowledging that they need someone who actually has an imminent actual injury traceable to FDA approval. But whether this satisfies it, I think, is going to be an interesting question for the court, and how they resolve the organizational standing question, which would raise as part of an issue whether you can get standing just based on the resources you have spent or invested in trying to fight a particular issue. On the merits, the question is, as I said, this is probably the first time, as far as we can tell, that any court has restricted access to an FDA-approved drug by second-guessing FDA's expert judgment about the conditions required for that drug's safe use. The FDA drug approval process is an extraordinarily elaborate one that requires a lot of expertise. And some of the Fifth Circuit's decisions about what kind of clinical studies are sufficient to satisfy drug conditions, the conditions under which a drug can be prescribed, are really complicated decisions that, while there may be some issues that are generally viewed as, an agency getting out beyond their skis, this falls really within the FDA's core competencies. So the question will be how the court does that. And as we all know, drug development is an extraordinarily expensive, time-consuming, lengthy process. The time from when you begin trying to develop a drug to ultimate approval is long. And this potentially really upsets the settled understandings of how you get a drug approved, whether once it is approved, it can remain approved, and who has standing to challenge it. And so I think the industry in general is looking for some clarification on whether these long settled rules are actually in question or not, and whether courts can revisit the FDA's judgment in these cases.
Thanks, Dan. Before we move along, there is a question about the cargo case that someone has directed to Erik. Do you think the Sixth Circuit decision in Hardin, based on the rule of lenity, essentially sidestepping grappling with the definition of a machine gun will be repeated in the Cargill case in the U.S. Supreme Court?
I don't think so. I think that they will engage, at least substantially engage, in the definitional question, only because when they turned down an earlier cert petition out of the DC Circuit on this issue, they really wanted to know what courts thought the statute said. And I think in some ways they would almost rather duck the other way and not create a broad rule of lenity that will potentially come back to bite them in the SEC context, in other criminal laws. So they may be forced to deal with lenity as an alternative, but I don't think they're going to duck the statute. I think they're going to want to say, we think this is the better one, and even if it was not perfectly clear, then lenity would be a thumb on the scale.
Michael, real quickly, how do you think that the justice's consideration of Chevron and the relentless and Loper Bright arguments might have an impact on questioning or how they craft their opinions in cases like Cargill and Hippocratic medicine in the second part of the term?
I don't think that the Chevron cases or the Chevron deference question is really going to play much of a role in either of those cases. I think Erik pointed out rightly that the government itself isn't even invoking Chevron in Cargill. And I think Chevron has become the case that shall not be named in a lot of cases, even where it's being advocated by the government. We talked about the Murray case. There was an issue lurking in the background there about whether the Department of Labor's Administrative Review Board gets deference under Chevron for its interpretations of the statutory language. The court didn't touch that issue. So I don't think there's any reason that they would address it in Cargill, where the government's not even pushing the point, and it may produce a separate opinion potentially. But I think the actual Chevron cases this term are going to probably suck up all the oxygen on the question. And in Hippocratic medicine, that's more of as Aim was saying, more of an arbitrary and capriciousness kind of question rather than interpreting the statute. So I don't think Chevron's really in play there. And even if they were, I don't think the court would really want to touch Chevron.
Jonathan, any thoughts on either of those two cases before we move along?
Yeah, I'll add 2 quick points in the Cargill discussion. The first, I think I'm more skeptical than Erik that the rule of validity is going to have a lot of work to do in that case. I am personally a fan of the rule, but the court seems not be, and they've said repeatedly that it's only grievous ambiguity that will trigger it. If we know anything from the Chevron cases, is that this court does not find ambiguity very often. Most recently, no justice other than Gorsuch and Jackson were willing to sign on to the rule of validity section of the Bittner decision last term. And although that was a civil case, maybe more problematic is Justice Kavanaugh's separate opinion in Wooden, where he wrote to respond to Justice Gorsuch's invocation of the rule of validity to say that it shouldn't be expanded beyond the grievous ambiguity. And instead, the court should look to mens rea to address the sort of fair notice concerns that underlie that rule. So my suspicion is rule of validity will not see a great revival or even do a lot of work in the Cargill case. The other thing I'll note about that case is that Jonathan Mitchell is supporting the challengers there. He inserts into his brief a challenge to the actual relief or non-relief, as he puts it, that was granted to Cargill there, and brings up back to the fore this question of universal vacatur under the APA. So the last time that came up, the government's position has long been that there's no such thing as universal vacatur under the APA, and you should get party-specific relief, just like their position is in other cases with regard to universal injunctions. The last time the SG made that pointed argument, you might remember, the court was aghast, at least the former members of the DC Circuit. Chief Justice Roberts said that was well settled, that the DC Circuit were issued that sort of relief 5 times before breakfast. It was a hoot of an argument, and then the court avoided the issue altogether when they issued their decision. So I'll be curious to see if it gets more play, that argument in this case.
Staying with Jonathan for a minute, every term has at least one sort of so-called business case whose question presented looks mind-numbingly complex, but maybe even boring, but the case is really significant. You've already mentioned this case, the Warner-Chappell Music versus Neely case, which involves the discovery accrual rule and a statute of limitations, which are very lawyery sort of things. Jonathan, what we be watching for as the court hears arguments in this case next week?
Yeah, so I think the biggest thing I'm watching for in this case is sort of how broadly the court wants to go in deciding the question. As you say, the ostensible question presented before the court is a pretty narrow split among the circuits about the scope of relief in a copyright case and the accrual rule. It comes out of this decision from Petrella v. MGM in 2014, where the court there held that the doctrine of latches was not available defense in a copyright suit. There, the plaintiff had sued MGM for copyright infringement based on the alleged copying of a screenplay in the 1980 film Raging Bull. And then the plaintiff had waited nearly 30 years to sue on that infringement, sued in 2009. But because copyright infringement happens every time a new copy or a new display or a new production is made, they were able to look back and continue to sue, even they've been 30 years hence. The court there held that the latches wasn't a defense because there's a statute of limitations, but it said there's a 3-year statute of limitations that would limit damages for infringement before only going back 3 years. Since Petrella, the courts of appeals have a split on how that 3-year window applies, where the discovery rules apply to the statute of limitations. Most courts of appeals have held that in a copyright case, you can rely on a discovery rule, and so it's not just 3 years from the infringement, but could be 3 years from when from when the plaintiff discovered or reasonably should have discovered the infringement. And so the question is, that's what the circuits is, whether in a case like that where the discovery rule applies, is there still a 3-year cap on the damages you can get, or does it stretch back to the infringement, however long it goes, that you didn't discover for many years? So that's a sensible question before the court. When the case came up, the petitioner in the cert petition said that's the split, but you could also resolve whether there is a discovery rule for copyright claims at all. The court has been pretty skeptical of those sorts of claims in recent years, where they weren't expressly codified in the statute. And I think that's probably the better argument for the petitioner, is not that there is this sort of 3-year cap on damages, even if your claim is timely going back 10 years, but rather that there's no discovery rule at all. The court granted the petition, but then rephrased it to say that to sort of assume that discovery rule applies and asks just that narrow question about 3 years, a 3-year damage cap. Undeterred, the petitioner before the court has argued the broader question that discovery rules should not apply at all in copyright cases. They do that with the support of the Chamber of Commerce as well, and sort of push the court to go further. And so I think I'm curious to see if the court takes up that invitation and sort of what they say. I think there are sort of 3 issues that I'm curious to see if the court will provide some guidance. The first is that one, as I say, the bigger question about the discovery rule, and that's a question that could have implications not just for copyright law, but for claims sort of across different areas of law. If they continue to narrow and make clear that without an express indication in the statute there is no discovery rule, that would have pretty broad implications. The second thing I'm looking at is whether the court will provide any guidance on the scope of review under 1292B. In this case, this is actually up there in an interlocutory appeal under 1292B, and the district court didn't certify the discovery rule question, and the 11th Circuit didn't address it. Respondents point that out as a reason not to reach further in this case. And the third, and this is a particularly one of interest to me as a Supreme Court practitioner, is if the court will say anything more about this sort of move that the petitioner has made here in trying to push the court to answer this broader question. The court has been quite annoyed in recent years about bait and switch tactics, where a petitioner will raise one question in the cert petition and then sort of pivot at the merits. To their credit, the petitioner did not do that here. The petitioner was quite clear in the cert petition that this case presented both the narrow question where there was a split and this broader question about discovery rule. So he can't be dinged for that. But the court also rephrased the question in a way that I think most naturally read is to tell the petitioner that they were interested only in the more narrow question. So we'll see how the court receives the broader arguments.
Thank you, Jonathan. So state versus federal authority, certainly we heard a lot about that in the Trump versus Anderson oral argument last week, although the specific concept of federal preemption really wasn't in the question presented or at issue there, but it is squarely at issue in the Cantero versus Bank of America case, in which WLF filed an amicus brief. And the court's been all over the place lately on preemption. How do you see this case coming down?
So by the question in Quintero is whether the National Bank Act, as amended by Dodd-Frank, preempts the application of state escrow interest laws to national banks. In this case, there's about a 50-year-old New York law that requires that banks pay 2% interest on mortgage escrow accounts. And the Second Circuit in this case said that the application of the New York statute to national banks was preempted by the NBA, which I think was less in question, but the way that they did it raised some significant issues. So this section 25B says that state consumer financial laws are preempted as applied to national banks only if such a law prevents or significantly interferes with the exercise by a national bank of its powers. And that sort of follows the Supreme Court's decision in Barnett Bank of Marion County versus Nelson. So the question here was how the Second Circuit did this. And the Second Circuit applied this sort of control test. What it said was, instead of applying the significantly interferes with standard, which is a pretty case-by-case inquiry and fairly factually specific, it applied a sort of control test, in which it said the question is not how much a state law impacts a national bank, but whether it purports to control the exercise of its powers. It didn't rely on the Office of the Controller of the Currency's regulations, which also address the question of preemption. And this new test is one that is, even if one agrees with the result, there are some questions about whether that tracks the statutory language and whether it's an appropriate standard to apply. And this is a case where the SG weighed in and took the position that what should happen here is vacator to apply the proper standard of preemption. They said this isn't a case where the court should try and figure out the result of that proper standard itself. It should apply this question about whether this substantially interferes, but it doesn't need to determine the actual result. So we'll see if they do that and if that actually adds some clarity. I mean, as we all know, preemption is fairly muddled. Although I think the general consensus is here that even if the result was right, there may be some questions about how the Second Circuit got here and some real questions about whether the Supreme Court would adopt a similar approach.
And so the final case we'd like to address is one that really does impact everyday citizens, businesses, especially in larger cities. The case is City versus Grants Pass, Oregon versus Johnson. And it involves a city ordinance and the 8th Amendment. Erik, you're just going to be authoring an amicus brief in this case. How does a city ordinance implicate cruel and unusual punishment?
Well, it's a stretch to say that it does. It implicates a variety of things. I'm just not sure it's cruel and unusual punishment. But the way you get there is if you have something that criminalizes behavior, in this instance, it would be the claimed involuntary behavior of being homeless, and the natural implications of being homeless, which is you need to stay somewhere other than the home you don't have. If you criminalize that and penalize people for that, that's either cruel and unusual or maybe an excessive fine if it's a fine. But you can sort of see how you get there. If you criminalized having red hair and threw them in jail for a month for having red hair, perhaps in some sense that would be cruel and unusual punishment for the non-crime of having red hair. The trouble in Grants Pass, of course, is there is behavior that violates a law that's not facially ridiculous, that says you can't camp in the public streets and public parks and whatnot, and that try to regulate the use of public space. And then the question becomes, but if you're involuntarily homeless, does the involuntary need to camp there somehow mitigate the crime? I would think that you would deal with that in common law principles like the voluntariness of the criminal act, whether or not you can be held criminally accountable. Maybe it's even a due process question if you literally couldn't do anything about it. But cruel and unusual seems a big stretch. The thing that will be interesting about the case, other than its obvious economic impact on states, particularly warm weather states that have a lot of homeless that tend to go there, like California, where my client is located, Pacific Research Institute, is how they deal with the text, history, and tradition mode of reasoning as they go through the 8th Amendment. Obviously, a number of judges have invoked that. It's become the mode of analysis pretty solidly after Bruin, the gun case, the gun carry case. But it was there in lots of other cases before that, to greater and lesser degrees. And the question is, are we going to emphasize text more? Are we going to emphasize history, tradition? I've always thought of it as text read in light of history and tradition, but the court seems to be leaning a little bit on occasion to just history and tradition, where the text can be read however you feel like it, potentially. There will be a lot of discussion about what was the world like back then. Could you camp in the middle of the town? Could you not camp? Did we care if you didn't have a house? I imagine you'll see a lot of historical analysis and how the court deals with that and deals with analogies to that. I think will be more interesting in some ways than the straight up, does the Eighth Amendment apply? Because it probably doesn't.
So if anyone has any questions for our speakers, please go ahead and put it in the Q&A. I'll ask one more question to everyone. The court's going to be hearing and considering cert petitions for the next term, for the next couple of months. Are there any that you're watching that we should be watching, that people that are concerned about how business is regulated or civil justice issues, those sort of things? And whoever wants to go first, please feel free to jump in.
I'll say I'm been tracking the court's consideration of Coalition for TJ, the Fairfax County School Board. That's a case that concerns changes to the admissions policy at a secondary school, the Thomas Jefferson High School in Fairfax, Virginia. The challenger argued that the school's facially neutral policies were in fact unconstitutionally motivated by a desire to discriminate on the basis of race, for racial balancing there. I think in some ways it's a natural follow-on to the court's decisions in Harvard and UNC. The court has now rescheduled that petition once and relisted it 4 times. Sometimes that means the justice is writing a dissent from denial, and sometimes it means, as we've seen in recent years, that there's some wrangling going on behind the scenes about whether to grant or not. So curious to see how that turns out, if the court wants to dive back into affirmative action or something like it very soon.
Does the denial of cert in the West Point case give any indication one way or the other, do you think?
I don't read it too. I think that was you're here too soon. Let's let this play out, build a record, and come back.
Okay.
I'm watching the Range case out of the Third Circuit, which deals with felon in possession or misdemeanor in possession. It's a follow-on to Rahimi. They're holding it for Rahimi. I think sensible folks probably think that Rahimi is going to lose because he's such a bad actor. The notion that the restraining order against the person who waved a gun and threatened a gun and pistol whipped people, that seems pretty easy. Maybe there's a due process question there, but Range was more of a minor crime that's disqualified a fellow from owning a firearm. And that matters to this community in part because there are lots of felonies out there that are sort of businessy felonies that have nothing to do with your sort of natural violent tendencies to shoot people. And so those cases have been popping up. There's another one, I think, out of the 11th Circuit with some good opinions about why nonviolent people who have served their time can't exercise their constitutional right to hold a gun. And the implications of that are all interesting, right? As to how that plays out on voting rights, how that might play out on free speech rights. If you can, if the reasoning is you're just a bad person for having committed a felony and not trustworthy citizen, I can apply that reasoning in a lot of places. So I'm hopeful that, given that Rahimi's facts are terrible, perhaps Range's facts, which are a lot better, will help the court, walk that line a little bit better.
Anne, are there any you're watching?
Yeah, so 2 that I'm interested in. One, Oklahoma versus United States, which involves horse racing and the Horse Racing Integrity and Safety Act, which came about after a series of highly publicized incidents with horses on racetracks. And it raises a question about the private non-delegation doctrine and the anti-commandeering doctrine. So it'll be interesting to see if the court has any interest in taking that on. I'd be curious about what my fellow panelists think of the odds. And then the other one that I think is interesting as well is the medical marijuana case. It's by the maker of CBD products, who asked whether economic harms that result from personal injuries actually count for purposes of a civil treble damages action under the Racketeering, Influence, and Corrupt Organizations Act, which has become a pretty broad and powerful tool for some plaintiffs' counsel going after companies whose businesses they don't like.
Michael, anything that you're taking a look at?
Well, maybe not quite as hot button a topic, but still potentially important is an ERISA class action case coming out of the Ninth Circuit, AT&T Services versus Bugilski, where the Ninth Circuit split explicitly from the Third and Seventh Circuits in holding that if you're a retirement plan and you contract with an administrative services provider to provide, like record keeping services and the like, that's the prima facie violation of ERISA's prohibited transactions provision. So we've seen a lot of ERISA class actions filed against plan sponsors and employers over the past few years. And if that decision from the Ninth Circuit holds up, you know, I would think that that's the next frontier for this kind of litigation. So it's definitely something to watch if you've got a 401k plan or something like that.
Any other thoughts anyone would like to share before we bring the proceedings to a close? Seeing as none, thank you very much for joining us today, all of our speakers, everyone who joined us online. This program has been recorded, so if anyone joined us late or knows of anyone who might want to see it, it'll be available on our website hopefully later on today or tomorrow morning at the latest. And should be interesting to see what happens with the rest of the term. Thank you, everyone.
Thank you.
Thanks,
Thank
Ed.
you.